Conflicts are bound to happen when states, investors, entrepreneurs engage in business dealings. How these conflicts are handled determine the continuity, completion of these dealings. My name is Damali Kataire. I'm a lawyer by profession. I practice law at Butagira and Company Advocates, Mbarara, Western Uganda. I hold Masters of Laws in International Dispute Resolution from the University of London. I'm a member of the Chartered Institute of Arbitrators, one of the largest world community of professionals who are skilled and trained in handling conflicts at ADR level. Yes, conflicts can be looked at as meaningful engagements which can change lives once handled the right way. And in the other way, conflicts can turn to be disastrous to projects and investments. I'm here to talk about alternative dispute resolution. Dispute resolution alternative is the best way to handle disputes when they arise. For a long period of time, whenever these conflicts arise, people run to court to file suits to have their issues determined by court. But we are aware, especially in African countries, that our court systems have a lot of challenges due to the resources allocated to them to handle these conflicts and other things, which leads to delay in determination of these conflicts. And of course, bearing in mind that, for example, Uganda, we inherited our legal system, which is common law, from our colonial masters. And the common law system uses litigation as the major way of dispute resolution. And this common law system and the litigation system, the litigation process is more of adversarial in nature. What do I mean by adversarial? When parties file suits in court, they have a strained relationship. They start looking at one another as enemies. In most cases, the projects come to a standstill. They can no longer talk to each other and can have meaningful conversation concerning their contracts, which affects the completion and sustainability of these contracts. So it's high time that people have started looking at alternative dispute resolution instead of running to litigation. It is alternative to litigation. It is alternative in a way that for this time, when people decide to resolve their issues through alternative dispute resolution, they will have a lot of say about who, when, how much, and that, for how long this dispute should take, which is a very good thing, especially for contracts which are commercial in nature. One of the ways that can be used to resolve these conflicts is negotiation. Negotiation is whereby the two conflicting parties get together and agree on how to end this conflict. It is the cheapest since they are not paying anybody. They are the only two conflicting parties negotiating among themselves as to how they should end their conflict. Again, it is the most convenient because the parties choose as to when they should sit, for how long this should take to be resolved. And at the end of it all, they agree on something which both of them own, and no one is pulling rope with the other. And the relationship, in fact, ends up being more strengthened. The projects continue to be running. So it is one of the best ways on how parties can resolve their conflict. And they have a lot of options as to how their dispute can be resolved. as long as both of them agree on that option and it is enforceable at law. Once that agreement is reached, it is binding on the parties, it is registered, and it is looked at as a consent judgment between the two parties, and the conflict is resolved that way. Another mode of alternative dispute resolution we can talk about is mediation. Mediation, the conflicting parties get a third party who is neutral. The third party is not to give the judgment or the ruling or decide on how the issue should be determined, but the third party this time is to facilitate the two people who are conflicting to have meaningful conversation on how they can end their conflict. Once the two parties have reached an agreement, the mediator, who is a third party neutral, will help the two conflicting parties to write down the agreement. And this agreement, it is binding between the parties as long as both of them have agreed that that is how they want their issue to be resolved. Mediator can be court appointed or can be party appointed. And this mediation, if it is court appointed, then the mediator will be paid by the court. If it is party appointed, definitely the parties will have to pay the mediator. They always decide, the parties, how they should pay this mediator, whether the one party is going to pay or whether the two of them are going to pay. So out of this mechanism, during this process when these parties are talking about how to end their conflict, their contract is running, their relationship is strained, and everything is moving on as normal, which is very good for commercial contracts and relationships. We also have conciliation as a mode of alternative dispute resolution. In conciliation, the conflicting parties accept to refer their conflict to a third party neutral, who is a conciliator, and the conciliator will look at the issue between the two parties and come up with different options on how this issue can be resolved. The conciliator's options to the parties are not binding per se, but the conciliator's options can guide the parties on which way forward, either to go for mediation, either to go for arbitration, or either to choose one of the options and have it binding upon them to end their contract, their conflict. That is one of the other options the parties can look at. It is cheaper, it is quicker, and it doesn't leave the relationship of the parties strained, which is very important, especially in contracts which are commercial in nature. We also have adjudication. In adjudication, it is the situation whereby the conflicting parties agree to refer their conflict to the third party, who is an adjudicator. And an adjudicator will look through the conflict, look at the evidence provided by both parties, and come up with a ruling. I would call it a ruling, which will be binding between the parties. An adjudicator's decision is binding on the parties, and it is final, which also comes very fast. It doesn't take a lot of time. And during that time, during that time when the conciliator is looking at the conflict, the business is going as usual, and the parties are not really looking at one another as enemies, which is very important, which is what we try to promote in contracts of commercial in nature. And of course, we want these contracts to be completed as per the timelines that were given from the beginning. We also have expert determination. In expert determination, it usually works in conflicts of different nature, especially where you need someone who has a lot of experience in a certain field where the parties are having conflict. So they identify that person with the relevant expertise, and that person looks at the conflict, writes the option on how this should be resolved, and that person's expert's opinion is binding and final on the parties. It is also very fast, it is also very cheap, and the decision that comes out from the expert, the parties are happy to live with it, since they are the ones who chose that person who is going to look at their conflict and how it should be resolved. We also want to look at dispute boards. Dispute boards are of two types. One of them is the dispute adjudication boards. Another one is dispute avoidance boards. In this video, we are concerned with the dispute adjudication boards. The dispute adjudication boards are put in place at the formation of the contract. It is normally a 3-person panel, which is put in place at the time when the parties are making their contract. This panel of the 3 people, the adjudicators, look at the contract, familiarize themselves with the rights, obligations, and timelines of the contract, and when any conflict arises, the parties refer that conflict to this board, which determines it very fast, and the decision of the dispute adjudication board is binding on the parties. And still, the parties will be happy to live with such kind of a decision, since they are the ones who chose the people who have determined their conflict, and they have trust in these parties that have determined their conflict. We also have arbitration. In most times when we talk of alternative dispute resolution, ADR, people's mind run to arbitration. But as you have seen, arbitration is not the only way how we alternatively can resolve disputes. It is one of the ways. So simply put, arbitration is whereby the 2 contracting parties at the beginning of their contract had put in their contract arbitration clause, choosing how their conflict will be resolved in case of any, by who, which law will be applicable. So once the conflict arises, the parties refer their conflict to the arbitrator, who can be one person or it can be a panel of 3 people. And this panel will look into the conflict, looking at the evidence presented by each party, and come up with an award, of which award is final and binding to the party, and it is enforceable at law. An award given by an arbitrator have the same weight like a judgment given by a court of law. So this becomes final, and it is, unappealable. It ends the conflict in its entirety, and the parties are free to move on with their obligations as per the contract. And during this time, when the arbitrator or arbitration panel is looking at this conflict, the parties are going their business as usual. They are still engaging meaningfully. They are still, happy. There is no straining of relationship, which we try to avoid in commercial relationships, especially when we go for court determination of these issues. What we see is people becoming enemies. People who started as friends in business dealings, they are now in court. They are not looking at one another. They have secured injunctions, stopping projects from running, and which affects the timelines for the initial project finishing timelines, of which we all try to avoid. I'm here to tell you that there is a better way how we can have these conflicts resolved without going to courts, where we shall spend a lot of time, where we shall end up having our relationship spoiled, where we shall end up having our project stalling, and instead we can have this dispute resolved and our contracts continue to be, moving as how we had planned from the beginning, and our relationships try to grow stronger and stronger for future meaningful other businesses. One would wonder why, with all these options available for parties to have their issues resolved, people are still running to court. Statistics show that by 2020 in Uganda, about 10% of the conflicts that were happening in Uganda were being filed in courts to be determined through court processes. And by 2024, 10% of the conflicts that were happening were ending up in courts. This is an alarming number given to the capacity of our courts, which has caused a lot of case backlog. Everyone in our country is aware of the issue of the case backlog, where cases are taking long in courts. And of course, it is a legal principle. We know that justice delayed is justice denied. Why would you still be interested in having your client, you as a lawyer, have a delayed justice, which is denied justice? Why don't we explain to our clients who walks into our chambers that there are other options, how we can have their issues resolved without wasting a lot of time and without wasting a lot of money? It is incumbent upon all of us who are involved in the dispensation of justice process to encourage the court users, the litigators, and everybody in the public to know about alternative dispute resolution. The government of Uganda has put in place a legal framework which enables us to be able to use ADR, and there is also a recent government policy about ADR, which is all about encouraging people to use alternative dispute resolution for meaningful resolution of disputes. Thank you for listening. I'm glad that you have got time to listen to this video. I'll be happy if you share it with another person, and if you reach out to me for more engagements concerning alternative dispute resolution. God bless you.